Let us begin with a question that appears simple but carries significant legal weight. Copyright law has always accepted that learning is lawful. A human being reads books, absorbs information, and later produces original content. That process has never required authorization. But what happens when learning is no longer human? When training is automated, is large-scale, and systematic, and when the output of that training can substitute, at least in part, original works. Does the legal assessment remain the same? This is the question that has once again come to the center of the legal debate, following a recent copyright lawsuit in the United States. Welcome to Diritto al Digitale. I'm Giulio Coraggio, a technology and data lawyer at the global law firm DLA Piper. Diritto al Digitale is the podcast where we explore the intersection between law and innovation, analyzing how technological change challenges existing legal frameworks and how regulation responds. The lawsuit concerns the alleged use of copyrighted books as training data for generative artificial intelligence systems. The claim does not focus on the output of AI systems, but on the upstream phase of training, specifically where the ingestion of protected works without authorization is lawful. What makes the case notable is not the claim itself, but its apparent objective: to obtain judicial clarification on whether large-scale AI training can consistently fall within the scope of fair use under US copyright law. This shifts the discussion from individual infringement scenarios to systemic legality. Many previous disputes concerning AI training data have ended without judicial decisions on the merits. Settlements resolve individual conflicts, but they do not clarify the law. In this case, the litigation strategy appears aimed at testing doctrinal boundaries rather than achieving a negotiated outcome. From a legal perspective, this is significant because fair use was developed in a context that did not contemplate automated processing, continuous reproduction, or training at industrial scale. The courts are therefore asked to apply established principles to a fundamentally different factual environment. A central issue is whether scale and automation are legally relevant factors. Fair use analysis traditionally considers purpose and character of the use, nature of the work, amount used, and market impact. AI training challenges all four factors simultaneously. The use is not human, the quantity is massive, and the economic effects are indirect but potentially significant. The legal question is whether training is transformative in abstract, but whether transformation at scale alters the balance underlying copyright law. From a European perspective, the discussion follows a different legal path. EU copyright law relies on specific exceptions, including the text and data mining exception, rather than an open-ended fair use doctrine. At the same time, the EU AI Act introduces obligations relating to transparency on training data, governance of data sourcing, and accountability across the AI value chain. As a result, the European debate is less centered on litigation and more on compliance, documentation, and risk management. This does not eliminate legal uncertainty, but it relocates it within governance frameworks rather than courtrooms. One emerging consequence of this debate is a shift toward operational solutions. Organizations are increasingly focusing on contractual allocation of risk, representations on dataset provenance, internal controls over AI procurement and deployment. For legal teams, the issue is no longer only whether training was lawful, but whether governance structures are adequate to manage uncertainty. This reflects a broader evolution from reactive legal defense to proactive compliance design. Importantly, these issues are limited to entities that develop AI systems. Organizations that deploy AI tools in business processes are increasingly expected to understand how systems were trained, what legal assumptions underpin their use, and how risk is distributed contractually. The distinction between developer and user is becoming less relevant from a governance perspective. Legal responsibility is progressively assessed along the entire AI lifecycle. Viewed objectively, this litigation does not seek to redefine copyright law overnight. It highlights the need for legal clarity in an area where technological capability has outpaced doctrinal certainty. The response will likely emerge gradually through a combination of judicial interpretation, regulatory guidance, and market practice. I will leave you with a few questions then on this topic. What is the right balance between copyright protection and artificial intelligence? Is this balance affected by the fact that AI is deemed to be the largest innovation in history? Can innovation be limited or better regulated due to copyright protection? I would like to know your thoughts on the topic. Send me an email at giulio.coraggio@yellowpiper.com. Also, register for the podcast, activate notifications so you don't miss the future episodes. And if you find this episode useful, please leave us a 5-star rating on Apple Podcast or Spotify. I'm Giulio Coraggio. This is the podcast Diritto al Digitale. Arrivederci.